on the history of the Hungarian law and Argentina. We thought we would start with the scientific discussion about our research, so that we can learn about each other work, scientific work. Thank you very much to our Argentine colleagues for participating in our workshop, especially Professor Viviana Kluger for her help in making this workshop possibility today. I really appreciate it. I would like to welcome the president of the Society of European Comparative Legal History, Professor Augustin Paris from the University of Maastricht, and Professor Cassano from the University of Cordoba. So thank you very much for accepting our invitation to this workshop. I hope this is a good starting point for us to share our research findings with each other in the near close future. It can also serve as a foundation, I hope that, for continuing our collaboration in the near future. So I would like to wish everyone a fruitful discussion. And right now, I am chair the first part of the workshop, and the first lecturer will be Viviana Kluger, professor, and he will speak about the circulation of the ideas on the legal models in university classrooms. Dear Viviana, dear professor, floor is yours.
Okay, thank you very much. I'm going to try to share my presentation. I'm not very familiar with this.
Marty, maybe
okay.
we'll have
Can you see the share screen in the
can
middle?
Can you see the presentation right now?
Yeah, it's perfect.
Perfect.
Okay, so can I go ahead?
Yeah.
Okay.
Yes.
Okay. So I'm going to speak about the circulation of ideas and legal models in university classroom through an example using doctoral thesis as the source of research. The doctoral thesis presented at the University of Buenos Aires on the second half of the 19th century and the first decades of the 20th century. So first, I'm going to make an introduction in order to let you know the objective of this presentation, that is to determine which legislations are invoked and which authors are cited, and how, through doctoral theses or doctoral dissertations, legal models circulate. So the sources, as I said, will be the doctoral thesis from the University of Buenos Aires about family law, contracts, and hereditary possession. But let's move to the legal ideas that were circulating in Argentina in the middle of the 19th century. And first of all, in 1869, the Argentine Civil Code was approved, which entered into force in 1871. And during that period, the ideas that were circulating were those of a legal eclecticism that was a set of elements of different origins and levels, the tradition, the rationalist, the Enlightenment, the historicism, the scientific law, and an emerging positivism. And also, we were influenced by the German legal science, especially Savigny's system of modern Roman law, through a French version that had been published in 1855, and the French doctrine of the commentaries on the French Civil Code by Duranton, de Molhomme, Marcadet, and Troplon, and also some Anglo-American legal works. And we in Argentina, we are particularly interested in works about federal government, political liberties, trial by jury, and the works of Joseph Story. And also, we received the influence of laws and authors from other countries, and this gave place to the emergence of a new discipline, the comparative legislation. And what is comparative law? Comparative law is a discipline that compares the similarities and differences among the various legal systems in force around the world, with the objective to understand and improve the legal system of a given state. And this discipline has had different denominations, like, for example, comparative legislation, comparative legal science, and this denomination of comparative law dates from the middle of the 19th century and early 20th century. And during this period, we had the beginning of the systematic study of a comparative law. And but the use of comparison is not something new. The use of comparison is something ancient. For example, in Greece, Aristotle studied 153 constitutions in his Politics, and also the Lycurgus and Solon traveled to study institutions before legislating. And also, if we move to the 12 tables, they brought information on foreign laws, especially Greek law. And then in the Middle Ages, also jurists made comparisons between Roman and canon law. And also there were comparisons between canon law and common law. But in the 19th century, there was a great interest in comparative law. Especially in German, it emerged through the works of Feuerbach, and this interest was transferred to France when in 1832, the chair of comparative legislation was created, and then we had the foundation of the Société de Législation Comparée, and then in 1876, the creation of the Office of Foreign Legislation, and then in 1900, the first World Congress of Comparative Legislation. And now let's move to the context, and let's speak about the legal education at the University of Buenos Aires Law School in the training of jurists. In 1821, the University of Buenos Aires was founded. And when it was founded, it was divided into 5 departments, one of which was the Department of Jurisprudence, which in 1874 was transformed into the School of Law. And this School of Law of the University of Buenos Aires gave the degree of Doctor of Jurisprudence after the defense of a dissertation or a thesis. And now, before moving to the thesis and before analyzing comparative law in the thesis, we must find out about the sources of the Argentinian Civil Code regarding legislation and regarding doctrine. So, The forces of our Argentinian civil law of 1869 regarding legislation were a wide example of codes. Our codifier, whose name was Dalmacio Vélez Sarsfield, who was born in the province where José was born, Córdoba. Dalmacio Vélez Sarsfield, our codifier, had a deep knowledge of foreign legislation. And we know this because of the references, the concordances, and the notes that he put in his code, the footnotes that he put in the code. And through these references, we learn that his main source was the French Civil Code of 1804, because he used 2,282 articles from the French Civil Code, and about half of them were reproduced, and the other half, 445 articles were directly copied from the French Civil Code. But other major source of our Civil Code was a Brazilian work called Esbozo by Arturo Augusto Teixeira de Freitas, who was a Brazilian jurist, and our codifier was inspired by him regarding matters relating to persons. And other codes and drafts that had an influence in our codifier were the Austrian Code of 1811, the Landrecht of Prussia, the Bavarian Code, the Italy Code of 1865, the Code of Louisiana of 1825, the Code of the Netherlands, the Code of Chile by Andrés Bello, and other codes like the Codes of Sardinia, Tuscany, Parma, Naples, Haiti, Vaud, and the Garcia Goyena draft, the Spanish author, the Code of New York, and the Code of Uruguay. And the doctrine that influenced our codifier was mainly the work of French jurists such as Aubry and Rowe, de Molhomme, Troplong, Sachery, Duganton, Marcadet, Merlin, Mourlon, and Laurent. And also some German jurists such as Savigny and Mainz. And let's move now to a comparative law in the thesis. First of all, we must answer the question, why did doctoral candidates use comparative legislation? Why did they bring comparative legislation to their thesis or to their dissertations? They could use this comparative legislation to support an argument, to reject an argument, to demonstrate erudition, to highlight similarities and asymmetries, to interpret a legal rule, or to assist in interpreting an institution. But this use of comparative legislation in their dissertations did not necessarily imply that they agreed with the cited legal model, because they usually stressed that the conditions to be inspired or to use foreign models was to consider if these solutions or interpretations were considered the historical and legal context because they were particularly concerned about not imitating foreign models that were inappropriate. That's why they consider especially the historical and the legal context. If to see or to check if these authors or if these legislations could be applicable. About the citation style in the dissertations. How did they cite? The students cited the names in an incomplete form. They showed incomplete names, no indication of works where was cited. When they mentioned an author, they not always mentioned the book, the work, and many times they did not indicate the page. That is to say, there were no page references. And now let's move to our final point, that is comparative law in doctoral thesis. First of all, we are going to speak about legislations. Which legal systems did our students cite in their dissertations? Legal systems from all areas and regions: the Egyptian, Hebrew, Persian, Greek, Roman, Spartan, Germanic, and Aztec customs. Also, authors from all areas, for example, Plutarch, Tacitus, Juvenal, Visigothic law, Castilian law, and also something very important is that the sources of the Argentine Civil Code that I have just mentioned were the starting point for doctoral dissertations. That is to say, the influence of the authors and the legislation that our codifier had cited. So regarding legislation, I have this chart in which you can't see the column that is on the left side. I don't know why, but I have a column in which I place the issue, and then this column about the foreign legislation that was cited, and then this graphic in which we can see that, for example, foreign legislation concerning hereditary tenure was cited in 5 theses, and 14 foreign codes were citing regarding contracts, for example, or 25 legislations were cited regarding child status, and so on. I don't have time to go in detail through this graphic, but I don't have any problem in sharing this later on with you. And then regarding doctrine, I did the same. This chart is in better condition. You see that, for example, regarding marriage annulments, our student cited, for example, Marcadet, Duranton, Toulier, Duverger, Portalis, Arens, Demant, and so on. And then regarding child status, they cited all these authors. Regarding paternity determination, they citing these other authors, and so on. And did they cite Argentine doctrine? Yes, they did. They cited Argentine doctrine, for example, regarding child status. They cited Segovia and Tejedor. Regarding divorce, they cited Argentinian civil code commentators, like, for example, Llerena, Segovia, Carlos Tejedor, university professors, like those of the University of Buenos Aires, like Wenceslao Escalante, Emilio Lamarca, Aristóbulo del Valle, and so on. And what about case law? Did they cite case law? I found that there was limited references to case law, probably due to the fact that there was a lack of publications related to case law. There was no systematic publication of case law, or publications were not accessible to the general public, or only a few important rulings in official gazettes or private legal journals were available to the public. So, to conclude, regarding legislations, our students cited the codes that were cited previously by our codifier. Regarding doctrine, our students also cited the authors cited by our codifier. They also citing the teaching of their professors. They compared domestic and foreign doctrines, and they also established dialogues between legal scholars, and they reconstructed these legal discussions. Who is referred to? The Napoleonic Code advisors, the commentators of the Napoleonic Code, the representative of the Pandectic School, the representative of the Historical School of Law, the rationalist, and German, Spanish, and Italian jurists. And to a lesser extent, British, American, and Brazilian philosophers, politicians, canonists, economists, sociologists, anthropologists, commentators of the Argentine Civil Code, professors of the University of Buenos Aires. And that's it. And thank you very much for your attention.
Thank you very much. This very informative presentation related to using the foreign models in the codification process and how compare this with the comparative law in the practice. It is very interesting, the two ways you can see in Argentina and, for example, in Europe, but we have some similarities. Of course, the next presenter will be Augustine. Dear Augustine, floor is yours, and please deliver a lecture, Legal History, Comparative Law, and the Circulation of Legal IDs in Argentina.
Thank you. Good afternoon, and thank you everyone for joining. I thank Norbert and Viviana for the invitation to speak in this wonderful forum. The Republic of Argentina offers a fertile ground for the study of the development of legal history and of comparative law. My presentation explores the development of these disciplines in Argentina. My focus is in the first half of the 20th century, a foundational period for both disciplines in Argentina. It focuses on actors and institutes that helped secure those developments. The presentation is divided into three parts. First, it alerts on the efforts that took place in Argentina regarding the development of legal history. Second, it looks at the developments in comparative law. And third, it shares interdisciplinary reflections, opening the door for comparative legal history. The presentation aims to confirm that disciplinary developments resulted from a circulation of ideas that was triggered by a synergy of efforts. Let us move to the first part of this presentation. Let us start with developments in legal history. Here I follow closely my doctor father, Abelardo Levalli. I follow a work he published in the journal Comparative Legal History and that I had the honor of translating into English. The first chair of legal history in Latin America was created in Peru in 1875, while in Argentina legal history was taught in local universities as early as 1890. In Latin America, legal history grew significantly during the first half of the 20th century, and Argentina was no exception. In the first decades, a positivistic sociological approach to law spread in the region. Juan Agustín García, and Carlos Octavio Bunge followed that approach in Argentina. Garcia was a sociologist interested in the description and study of national social phenomena. He published in 1896 his Introduction to the Study of Argentine Law with a historical background. Further, in the year 1900, he published his seminal work entitled The Indiano City, which takes a sociological perspective by exploring the minutes of the Cabildo, or the government institution of Buenos Aires. Bunge, being attracted to the theories of Charles Darwin and Auguste Comte, interacted with the Spanish scholar Eduardo de Hinojosa, triggering a fruitful relationship between Spanish and Argentine historiographies. Bunge aimed to offer the first treatise on Argentine legal history, dealing with Native American, Castilian, Indiano, and national laws. In the following decades, the addition of source materials placed historical studies in a paramount position. Ricardo Levene can be considered the forefather of legal history in Argentina. He held the chair of Introduction to Law at University of Buenos Aires for the remarkable period of 1919 until his death in 1959. He established an Institute of Argentine and American Legal History in 1936 at that university and a Journal of Legal History in 1949. Levaggi, my doctor father, mentions two contemporaries of Levene that merit attention. Jorge Cabral Texo, who drafted two seminal works on the Argentine Civil Code, works that students that drafted the thesis, like Viviana mentioned a few minutes ago, most probably benefited from in the future. And Emilio Ravignani, who directed the collection of source materials on the Argentine Constitution. I want to add a third name that I identified when preparing for today, for this Argentine-Hungarian and Hungarian-Argentine meeting. I refer to Dr., and I'm sorry for the pronunciation, Cornel Zoltán Mehez, M-E-H-E-S-Z, Mehez, who was born in Hungary in 1915 and who studied in the beautiful city of Szeged that is welcoming us today. He acquired Argentine citizenship in 1934. He was a renowned scholar in legal history of Rome and Greece. This colleague had a remarkable private library, one of the most rich libraries in Latin America. And he was inducted as a member of the National Academy in Argentina in 1981. And in the induction talk, when they inducted this colleague to the Academy, they made a special reference of his trip back home to Szeged, where he had studied, and how he returned after 36 years, and how moving it was, and how he was able to meet with some of his professors there. But let's continue. Legal history continued gaining momentum in Argentina beyond the period that I cover today, both in the region and in Argentina. In regards to the region, as early as the 1930s, Levene acknowledged that the national scope did not provide sufficient ground to understand local situations. Other branches of the same tree needed to be looked at to reach to other areas affected by Spain. This motivated studies on the Indiano period, a term that I used already a few times today. Indiano is the law that applied in Latin America since the 15th century, the conquest, until the 19th century, the independence. These Indiano studies gained importance since 1966 with the work of the International Institute for the Legal History of Indiano Law. Its 22nd Congress is taking place this fall in Mexico, and some of us will be attending. In regards to Argentina, the first biannual Argentine Legal History Conference took place in 1967, one of the earliest, I would even claim, in the entire world. The 31st edition will take place next semester, and you can join online. And Viviana and myself are in the organizing committee, and Viviana has presided these events for many years now. The gestational period in Argentina, we can agree, was fertile and involved actors and institutions from within and from outside. Let us move to the second part of this presentation. Let us explore developments in comparative law. An interest for this discipline can be sensed during the first half of the 20th century, though it can be traced earlier, like Viviana already mentioned a few minutes ago. Scholars aimed to reduce the exegetical approach to the law and to include other social sciences. For example, curricular proposals at University of Buenos Aires expected in 1904 that, and I quote, half of the courses of positive law would include comparative law components, end quote. Another example is found in the opening lecture for the academic year 1909 in Buenos Aires, when Wenceslao Escalante pointed to the need to include comparative law together with legal history. A third example is found at University of Litoral. There, the 1920 curriculum stated that comparative law would address industrial law, labor law, law of the railway systems, municipal law, and civil law. And remember that Argentina had at that time one of the biggest railway systems in the entire world. That's why even comparative law had to be used to teach the law of the railway system. Local efforts in Argentina can be traced back to 1925, when an Institute of Comparative Law was established at the University of Córdoba, a topic that our colleague Daniel Cisano has studied extensively. This can be considered the first Institute of Comparative Law in the Americas, and I'm sure Jose Daniel will tell us, well, from the title of his presentation, he will tell us what was happening in that place. Edouard Lambert informed readers about that institute in 1939 in the Bulletin of the Lyon Institute in France. There he highlighted the potential for the international projection of the work from Córdoba, bridging the Americas and Europe. Córdoba was active. The objectives of the Institute included the translation of legal sources, the creation of a comparative law library, and the organization of academic meetings. Translations soon took the stage. They exposed the Spanish audience to some of the leading authors in the old continent. Córdoba, like Daniel will tell us later today, welcomed émigrés, taking a fundamental part in the life of the Institute. Research visits were encouraged as reported in the pages of the Bulletin of the Société de Législation Comparée in France. In addition, comparative law endeavors found a forum within two bulletins in Córdoba. Bulletins were used as tools to spread legal ideas to domestic and international forums, what today we would call an email or a newsletter. All these efforts helped to develop networks of scholars interested in the discipline. The Institute was therefore instrumental in building bridges, inviting for dialogue across jurisdictions. Enrique Martínez Paz was the director of the Institute, but there were other important actors. For example, Roberto Goldschmidt, an émigré from the National Socialist Germany, who was welcomed first in Uruguay thanks to Eduardo Couture. Marcelo Finzi, who Daniel will mention now in a few minutes, acted as another important link, mainly with Italy and the narrative from that part of Europe. Let us see the events at the national level. The Argentine Association of Comparative Law was established in Buenos Aires in 1947 as a result of the efforts of a number of pioneers in the field, including Ignacio Winiski. Winiski traveled to Paris in the summer of 1946. There he attended a meeting led by Marc Ancel, in which they aimed to establish institutional collaboration between a group of Argentine jurists and the Société de Législation Comparée. An Argentine section was soon established, and the members of that section established the Argentine Association in 1947, one of the oldest associations in the world. Leopoldo Melo was the first president. Winiski, for many years Secretary General, advocated for interaction with foreign comparatists, organizing conferences with speakers from the Americas, Asia, and Europe. The Argentine Association was a result of synergy among actors, within and beyond national borders. It is currently active and has been operational without interruptions since its conception in 1947. Let us move to the third and final part of this presentation. Let me share some interdisciplinary reflections. Let us look at comparative legal history, something that we all care a lot for, especially our friends from SAHED, who organized last year the biannual meeting of the European Society for Comparative Legal History. An amazing event, I need to say with a big smile. Already in the 1950s, Benito Pérez stated that the Americas at large provided a fertile ground for the study of comparative legal history. In the 1960s, Enrique Aftalion from Argentina said that history needed to be global and that studies on legal history generally identified Spanish influences, but did not identify, for example, the US influence in public law or other types of influences. In practice, however, legal history was approached with a national focus. In Latin America, very few comparative studies of the national periods have been undertaken. There are some exceptions. In Chile, Bernardino Bravo Lira worked in the area of constitutional law, and Alejandro Guzmán Brito in the area of codification. The time for an in-depth exploration of a blend between legal history and comparative law is now ripe. I believe there are several favorable conditions for the development of comparative legal history in Latin America. The first condition is language uniformity. Spanish spreads in almost all jurisdictions. Exceptions are Brazil, where Portuguese dominates, and jurisdictions such as Haiti, where French is the official language. But those languages are not too far from Spanish. Language uniformity facilitates not only daily life and commerce, but also research activities. It is therefore easier to undertake cooperative works and access works drafted by scholars of other jurisdictions. A second favorable condition is that Latin American jurisdictions share common roots. These go back to the colonial Spanish and Portuguese periods. For example, Argentina, Bolivia, and Uruguay were part of the same viceroyalty of Rio de la Plata, and therefore share many aspects of Indiano law. Common roots should be also explored by the national period scholars to trace survival or eradication. Potential for cooperation is a third favorable condition and also applies to other parts of the world. As early as the 1980s, Alfonso García Gallo from Spain stated a need for cooperation in Latin America to elaborate legal history courses. He also advocated for fellowships that would help scholars gain skills and knowledge abroad and import it into their jurisdictions. Course books should have a comparative approach. For example, Abelardo Levalli included references to Mercosur in his course book on Argentine legal history. It now includes references to Paraguay, Brazil, and Uruguay. The development of comparative legal history in Latin America should be beneficial beyond the region. First, it could help better understand developments in Latin America. It could explain differences and similarities in the region. For example, European scholars sometimes tend to take an oversimplistic approach to the understanding of Latin America. A comparative legal historical approach may help reverse that tendency. It is many times said Latin America simply adopted the Code Napoleon, but that is an oversimplistic statement. A detailed study shows, like the one of Guzmán Brito, that there was also local elaborations and cross-pollination, especially from Chile, Brazil, and Argentina. There is a second aspect in which comparative legal history can be beneficial. A comparative approach could show that legal problems are not unique to a specific space. For example, many European institutions have been reproduced in America with different results. America could provide more case studies for the operation of European institutions and vice versa. It could be an open laboratory for study. Let me conclude by summarizing briefly in 1 or 2 minutes what we saw today. First, we addressed developments in legal history. There was a first positivistic sociological approach to legal history. This was followed by a period in which historical studies were placed in a paramount position due to the addition of source material. And beyond the time period, legal history continued gaining momentum. In regards to region, with the studies in Indiano law. In regards to Argentina, with the biannual Argentine Legal History Conference. Levene was the main architect of those efforts in Argentina. Second, this presentation focuses and develops in comparative law. Local efforts in Argentina can be traced back to the establishment of an institute in Córdoba in 1925. National efforts can be traced to the establishment of the Argentine Association in 1947. Efforts were led by actors that nurtured their work within institutes. For example, Martínez Paz and Winitsky engaged in bridge-building activities across continents. Third, this presentation enabled me to share some interdisciplinary reflections. The time is ripe for comparative legal history. I shared favorable conditions for its development, language uniformity, common roots, and potential for cooperation. I also shared two reflections on the benefits of engaging in this type of studies, better understanding of local developments, and being aware that legal problems are not unique to a specific space. Law is rarely shaped after one single occurrence, since multiple actors and institutes can trigger different changes. Occurrences are small tessera or bricks in a mosaic that fills with color with the synergy between actors and institutes. My presentation pointed to the development of legal history, comparative law, and hopefully of comparative legal history, and that results from the circulation of legal ideas among actors and institutes. I hope that our circulation of ideas today among actors and institutes also paves the way for more developments. I thank you very much.
Thank you very much. This very interesting presentation and the kind words of Agustin. So the last presenter is José Daniel Cassano, professor from the University of Córdoba, who will speak about Marcello Pinzé. So, dear professor, the floor is yours. Please deliver your lecture, of course, in Spanish language. So, but I circulated the English version to my colleagues. Thank you for it. It was very kind of you. So, Professor Cassano, the floor is yours.
First, I would like to thank Viviana and Norbert for the invitation. Second, although I will be giving my presentation in Spanish, I have tried to mitigate this by sending the text of my presentation in English. Los exilios y migraciones de pensadores, de letrados, científicos o intelectuales han constituido desde hace mucho tiempo una realidad que ha motivado el interés de los historiadores, biógrafos o ensayistas. En nuestro caso, abordaremos el caso de un jurista italiano, Marcello Pinzé, quien debió expatriarse con motivo de las leyes raciales de 1938. Este trabajo se enmarca en un programa de investigación que venimos realizando y que se propone analizar la conformación de la cultura jurídico-penal de Córdoba entre 1895 hasta 1958 y en particular la importancia que tuvo el derecho comparado en la formación de esta cultura. Este periodo que hemos trabajado, con el cual estamos trabajando, es decir, último cuarto del siglo XIX, se justifica, y durante el siglo XX, por supuesto, se justifica porque la Universidad de Córdoba, en lo que concierne a las ciencias penales, se caracterizó por la recepción de doctrinas provenientes del positivismo criminológico, especialmente italiano, aunque también de fuente francesa. Concepciones que, hacia fines de la década del 20 del siglo pasado, comenzaron a ser cuestionadas, en particular con las obras de Sebastián Soler, Ricardo Núñez y Ernesto Roque Gavier. Estos autores no solo criticaron el concepto de peligrosidad criminal como fundamento de la responsabilidad penal, sino que además cuestionaron los presupuestos epistemológicos de la disciplina, priorizando a través de la recepción de la Escuela Técnica Jurídica de cuño italiano y de la dogmática alemana el estudio sobre el contenido de la ley vigente en el país. Justamente, creemos que uno de los factores que contribuyó en este cambio de paradigma estuvo representado por los aportes que en el Instituto de Derecho Comparado de la Universidad Nacional de Córdoba desarrollaron expatriados europeos que buscaron refugio ante la intolerancia de las leyes raciales de Italia y Alemania. En ese contexto es donde cobran relevancia la labor desplegada por Marcello Finzi y Robert Goldschmidt. En este trabajo nos centraremos fundamentalmente en Finzi, cómo pudo insertarse en el ámbito cultural de Córdoba y su universidad, analizando distintos aspectos de la tarea que allí desarrolla. Cuando Finzi arriba a Córdoba, ya era un jurista con una gran trayectoria académica y con reconocimiento en Europa. No nos detendremos aquí en esa trayectoria italiana, pero esta ha sido estudiada en profundidad por diversos autores, entre ellos Elio Tavila. Nuestro objetivo aquí se centrará en la actuación de Finzi en el medio universitario de Córdoba. Marcello Finzi y su esposa, Adele Olsky, con motivo de las leyes raciales de 1938, decidieron expatriarse a Argentina. El ingreso a nuestro país no estuvo exento de complicaciones. En efecto, un tiempo antes, el decreto 8.972 de 1938 había modificado el reglamento inmigratorio vigente en la Argentina. Y como consecuencia de esto, para ingresar al país, los extranjeros tenían que contar con un permiso de desembarco otorgado por el Departamento Central de Inmigración, el cual, previamente, debía ser considerado por un comité consultivo interministerial. Incluso antes de la vigencia del decreto y cuando ya se había decidido la nueva política migratoria del gobierno, se instruyó a los cónsules a través de la circular número 11 para que negaran la visa a aquellos solicitantes que abandonaran o hubiesen abandonado su país de origen por habérselos considerado como indeseables o haber sido expulsados. En mérito de esta circular, en un primer momento le fue rechazado a Finzi su permiso en la sede consular ante lo cual lo tramitaba. No obstante este rechazo, y como sucedió con otros científicos emigrados, como fue el caso del filósofo Rodolfo Mondolfo, personalidades de la vida académica y de la política argentina lograron destrabar este obstáculo. En el caso de Finzi, fueron Sebastián Soler, por entonces profesor suplente de Derecho Penal en la Universidad de Córdoba y jefe de la sección de Derecho Penal en el Instituto de Derecho Comparado, que dirigía Enrique Martínez Paz, y el mismo gobernador de la provincia, Amadeo Sabatini, fueron quienes hicieron posible el arribo del profesor italiano a Córdoba. La actuación de Sabatini lo fue a pedido del propio Soler, a quien el gobernador conocía por haber sido uno de los juristas a los que encomendó previamente el Código Procesal Penal de la provincia. Por su parte, Soler había conocido a Finzi en Francia al coincidir años antes en una actividad académica en París. Marcello y Adela arribaron al puerto de Buenos Aires el 6 de noviembre de 1939. A los pocos días se trasladaron a la ciudad de Córdoba, donde los esperaba uno de sus anfitriones, Sebastián Soler. Ambos cónyuges habían obtenido permisos de residencia permanente. Radicado en Córdoba, Finzi fue nombrado profesor de la Escuela Provincial de Policía. Como recién lo dije, en 1939 había entrado en vigor el nuevo Código Procesal Penal de la provincia, un cuerpo jurídico que introdujo, entre otras novedades, la institución de la policía judicial. Dada la experiencia que tenía Finzi en esta materia, fue contratado por la provincia con la finalidad de que dictase un curso en aquella escuela. El 29 de agosto de 1939 se dictó en el ámbito de la Facultad de Derecho una ordenanza de creación del Instituto de Derecho Comparado. Agustín ya ha analizado aspectos de esta ordenanza, pero digamos simplemente, para completar la idea, que el instituto quedó organizado en 5 secciones, las que comprendían las siguientes materias: derecho civil, derecho comercial, derecho penal, derecho público y derecho procesal. El decano de la Facultad de Derecho, por entonces Jorge Núñez, en el discurso que pronunció con motivo de la inauguración del centro, el 19 de septiembre de 1940, señaló entre los propósitos del instituto el de reunir y coordinar en forma sistemática los materiales que muestren el proceso de preparación, discusión y sanción de los códigos y leyes nacionales y extranjeras, propendiendo así al conocimiento recíproco de la legislación del país y de otras naciones. Como una manifestación del tal cometido, también se fijó como objetivo la traducción de códigos y leyes de países extranjeros, debiendo mantenerse actualizada la información sobre las modificaciones que pudiesen experimentar aquellos textos. La dirección del instituto, como bien lo dijo Agustín, recayó en el catedrático de Derecho Civil Comparado Martínez Paz, jurista de gran versación que dictó, además de la cátedra recién aludida, Derecho Civil Comparado, las cátedras de Sociología y Filosofía del Derecho. Como jefe de la sección de Derecho Penal se designó a Sebastián Soler. Inmediatamente, Martínez Paz, por sugerencia de Soler, convocó a Finzi como secretario del instituto. La contratación de Finzi no fue casual, sino que encontraba fundamento en el público reconocimiento que el director del nuevo instituto tenía hacia la trayectoria del profesor italiano. Fiel a los propósitos que inspiraban al instituto, la primera tarea que se le asignó a Finzi fue de carácter bibliográfico, la confección de 2 ficheros, uno dedicado en particular al derecho comparado y el otro a todo el campo de las ciencias jurídicas y sociales. Para la confección del primero, Finzi tuvo en cuenta la sistematización de materias que había efectuado el propio Martínez Paz en su libro Introducción al estudio del derecho civil comparado, así como también en el programa de sus lecciones. Al poco tiempo se dio inicio a otra labor que tendría una gravitación muy importante para la cultura jurídico-penal de Córdoba: la traducción al castellano del texto del Código Penal alemán. Esta labor la desarrollaría Finzi juntamente con un auxiliar del instituto, Ricardo Núñez, epilogando en 1945 en una publicación que se tituló Código Penal Alemán, parte general y modificaciones posteriores, que editaría la Universidad de Córdoba. Asimismo, el director del instituto encomendó a Finzi, con la colaboración de Núñez, el dictado de cursos prácticos de derecho penal comparado, los que se desarrollaron periódicamente entre 1941 a 1950. Los principales temas abordados en estos cursos fueron, entre otros, los siguientes: el concepto de condición suspensiva en el derecho penal, 1942, el llamado dolo específico, 1943, los delitos de pluralidad de hipótesis, 1943, quiebra culpable y relación de culpabilidad, 1944, etc. Es interesante detenernos en la estructura de estos cursos porque muestra la familiaridad de Finzi, entre otras, con la ciencia jurídica alemana. Por otra parte, las materias analizadas evidenciaban un marcado interés por el examen de institutos jurídicos positivos concretos, partiendo, en todo caso, de una lúcida exposición de la cuestión por parte de la doctrina argentina. Muchos de estos cursos concluyeron en la producción de nuevos libros que realizó Finzi y que se publicaron en Buenos Aires. ¿Cuáles fueron las ideas pedagógicas de Finzi al momento de diseñar los cursos? Un aspecto destacable de su docencia ha quedado reflejado en uno de los informes que presentó al director del instituto con motivo de la realización de estos cursos. Concretamente, su concepción respecto al carácter participativo del proceso enseñanza-aprendizaje. El espíritu del profesor, dirá Finzi, no es el de proclamar autoritariamente su opinión, sino que desea y busca escuchar la de los otros bajo la crítica de la actividad razonadora de los estudiantes. En otro informe, correspondiente al año 1949, Finzi explicitó los criterios bajo los cuales seleccionaba los temas de evaluación. Criterios que se orientaban a formar en los participantes, antes que nada, una actitud reflexiva inspirada en el análisis concreto de las instituciones jurídicas que analizaba. En dos oportunidades, entre marzo y abril de 1941 y febrero y junio de 1946, el decano de la Facultad de Derecho, a propuestas del director Martínez Paz, le encomendó a Finzi sendos viajes de estudio a Estados Unidos de Norteamérica. En su primer viaje, Marcello partió con su esposa el 27 de mayo de 1941. Viajó con permiso temporal y con estatus diplomático. El viaje de Finzi coincidió con el realizado por el propio Martínez Paz, a quien el gobierno argentino, por decreto del 11 de febrero de 1941, había encargado realizar estudios sobre el gobierno de las universidades y sobre la organización y orientación de la educación en los Estados Unidos. En aquellos viajes, Finzi visitó distintas instituciones académicas vinculadas con el derecho comparado, por ejemplo, el Centro de Derecho de la Universidad de Michigan, el American Law Institute y el American Bar Association. Asimismo, examinó cómo se realizaba la enseñanza de la materia y la bibliografía utilizada, analizando incluso el fichaje de tal material y la organización de algunas bibliotecas especializadas. En estos viajes, nuevamente se pone en evidencia la preocupación de Finzi respecto del proceso de enseñanza-aprendizaje. Con su minuciosidad habitual, el profesor italiano describe el case system y el case method, señalando su opinión al respecto. La clase, dice Finzi, que debe tener con preferencia el carácter de una conversación que considera en primer término el caso práctico, tiene que elevarse a los principios, si no se quiere caer en el empirismo. Durante los años en que Finzi trabajó en el Instituto de Derecho Comparado, el profesor italiano desarrolló un pensamiento sobre su disciplina que compartía mucho de los planteamientos de su anfitrión. De hecho, Martínez Paz siempre había insistido en las características que debía tener la disciplina. Las leyes no las hace un movimiento original, dirá el director del instituto en 1945, sino bajo la sugestión de modelos. Esta factura exige conocer tales modelos sistemáticamente. Es necesario descender a las fuentes de las legislaciones y de las instituciones. Y para hacerlo, para llegar a esa fuente, es menester conocer sistemas extranjeros, pero debe descenderse a descubrir menudamente cuáles son realmente, no las fuentes supuestas, las fuentes aparentes de analogías o similares, sino el principio real que las informa. Saber derecho positivo, decía Martínez Paz, es saberlo comparativamente. Desde luego que esta concepción fue compartida por Finzi. Tempranamente, antes incluso de su radicación en Córdoba, ya Finzi lo había señalado de esa manera. En lo que atañe, por ejemplo, a la concepción que el profesor italiano tenía sobre esta temática, hay varios aspectos que merecen señalarse para demostrar la comunidad de ideas. Por una parte, tanto Finzi como Martínez Paz señalaron que el saber comparativo era primeramente un método de análisis del fenómeno jurídico y como tal debía ser enseñado. Por otra parte, y desde otra perspectiva, ambos juristas concebían a la disciplina no como un mero ejercicio de erudición, sino que por el contrario, su utilización debía tener innegables utilidades para el estudio del derecho vigente. Finzi lo había expresado tempranamente en 1908 en su obra I reati di falso, al expresar: la historia y la legislación comparadas nos serán sumamente útiles para la evaluación crítica del derecho positivo actual y nos proporcionarán las bases para una firme construcción jurídica. Otro aspecto que se puede observar en esta confluencia del pensamiento de Finzi y de Martínez Paz está vinculado al concepto de que conocer el derecho positivo es conocerlo comparativamente. Estas palabras traducen un pensamiento compartido entre ambos juristas y que estuvo presente en el caso de Martínez Paz desde la misma creación del Instituto de Derecho Comparado en 1940. Esta fue también una preocupación que desveló a Finzi. Buena muestra de ello es lo que consignó en su informe al curso de 1949. La investigación comparada puede y debe hacerse también dentro de una misma ley o código, si se quiere llegar a la construcción dogmática. Durante su estadía en Córdoba, Finzi participó además en otros emprendimientos culturales de envergadura. Uno de ellos fue la colaboración en la Revista Jurídica de Córdoba. Como principio general, el estudio de estas iniciativas permite observar la activa participación de grupos de intelectuales quienes utilizaban las revistas para definir su participación al interior del campo intelectual, así como al exterior de este, en relación con otros grupos. Como actores sociales inmiscuidos en las empresas editoriales, estos buscaban expresar sus inquietudes a través de este medio de comunicación y simultáneamente encontrar un espacio que legitimara la posición que deseaban alcanzar. Aparecen así las revistas como espacio de sociabilidad cultural. Y la Revista Jurídica de Córdoba, que hizo su aparición en número primero en 1947, tenía sin duda esa impronta. La obra de Finzi mereció una especial consideración por parte de distintos juristas locales. Por ejemplo, Sebastián Soler, Ricardo Núñez y Ernesto Gavier, entre otros, hicieron mérito de los trabajos del profesor italiano. Gavier, por ejemplo, en su nota al fallo Aborto imposible seguido de muerte, calificó el libro de Finzi, Il diritto preterintenzionale, como una excelente monografía y en diversos pasajes de su comentario mencionó y analizó la opinión del profesor italiano. Lo mismo sucedió con Ricardo Núñez. Por su parte, en el caso de Sebastián Soler, se advierte también un uso de los trabajos de Finzi, mencionando en su Derecho Penal Argentino de 1940, entre otros, el llamado dolo específico, la obra de Finzi, Previsione senza abolizione nel diritto penale y, por supuesto, il diritto pretenzionale. Por otra parte, también se advierte una pareja utilización de las obras locales, es decir, los trabajos de Núñez, Gavier y especialmente Soler, por parte de Finzi, quien en diversas obras posteriores, por supuesto, a su radicación en Córdoba, habría de citar a este pensamiento. Se resulta relevante señalar la valoración que respecto de la labor de Finzi en Córdoba realizara uno de sus compañeros, Ricardo Núñez. Cuando fallece Finzi en 1956, escribió una nota necrológica en donde describió muy bien el clima que caracterizaba al Instituto de Derecho Comparado en los tiempos que trabajaba Finzi. Decía Núñez, allí su labor, la de Finzi, fue múltiple y rendidora. De ello, como jefe de trabajos prácticos del curso mencionado hasta 1946, podemos dar fundado testimonio. El profesor desaparecido se ha referido más de una vez a esa labor, cuyo resultado más promisorio fue la formación de un ambiente científico al que contribuyeron la autoridad y la iniciadora personalidad de Enrique Martínez Paz, director del instituto, y el saber del profesor Roberto Goldschmidt, De allí salieron trabajos de investigación de real valor para nuestro derecho penal positivo y que fueron debidos en gran parte a los cursos prácticos del doctor Finzi. Con la llegada de Juan Domingo Perón a la presidencia de la República, la Universidad Nacional de Córdoba y sus facultades fueron objeto de diversas intervenciones. Como consecuencia de la implementación de la Ley 13.301, comenzaron a verse varios cambios que, en lo que respecta a la Facultad de Derecho, comenzaron por modificar el plan de estudio, eliminando algunas cátedras, entre ellas la de Derecho Civil Comparado, e introduciendo cambios en la estructura académica de los institutos de investigación que funcionaban. Así, hacia fines de 1950, por un periodo de tiempo, se suprimió el Instituto de Derecho Comparado, donde Finzi desarrollaba sus actividades. Por su parte, uno de los anfitriones de Finzi, Martínez Paz, ya se había retirado de sus funciones universitarias. Por entonces, tras la finalización de la guerra, había comenzado un proceso de regularización en las universidades de Italia. Y es así que la Universidad de Módena reintegró a Finzi a su cátedra para el año académico de 1946-1947. Sin embargo, se trató de una medida de carácter simbólico que tuvo el valor de una indemnización por el mal producido por su injusta separación con motivo de las leyes raciales y que estuvo encaminada a que Finzi alcanzara la necesaria antigüedad para su jubilación, la que finalmente se le otorgó a partir del 1 de mayo de 1951. Por eso, su retorno definitivo a Italia y su desvinculación formal con la Universidad de Córdoba recién ocurriría en el mes de abril de 1951, fecha en que Marcelo y Adel retornaron a su patria. Concluyo. El caso de Marcelo Finzi evidencia la existencia en Córdoba y su universidad de patrones de hospitalidad respecto de la inmigración intelectual. A diferencia de Buenos Aires, que se mostraba, al menos respecto del escenario jurídico, bastante reacia para las incorporaciones de aquellos exiliados, algunas provincias y sus espacios universitarios, Córdoba es una de ellas, pero también sucedió con las más nuevas universidades de Tucumán y de Cuyo, se caracterizaron por esta mayor apertura. En cuanto a la ponderación de las tareas de Finzi, debemos señalar que tanto a través de su labor de traducción como muy especialmente a través de los cursos de Derecho Comparado, constituyeron un medio fecundo para la recepción de ideas europeas, tanto italianas como alemanas, en el contexto cultural en que se insertaban sus actividades, derramándose incluso fuera del espacio parroquial cordobés, en la medida que, a través de proyectos editoriales nacidos en Córdoba y en Buenos Aires, por la difusión general que daba la publicidad de aquellas traducciones, darían visibilidad a autores alemanes y a sus prácticas científicas, la dogmática jurídico-penal, consolidando así un modelo de renovación en lo que concierne al estudio del derecho penal en tanto fenómeno normativo. Thank you very much for your attention.
Thank you very much. This very interesting presentation related to the criminal law, exactly the history of criminal law. And right now, I officially open the debate, the part of the remarks. So if you have a question or comments related to these topics, don't hesitate to raise your hand. Yes, Augustin?
Yes, thank you very much, Norbert. When I was preparing for today, I was looking into this Hungarian colleague, and I was wondering if you had any knowledge about him, or if you had or is this the first time you heard his name? You want me to spell him again?
Yes.
I can write it in the chat. Let me copy his name in the chat, because I was very curious.
Cornel Zoltán Méhész.
Yeah, it's now in the chat.
Yeah. Cornel Zoltán Méhész. He wrote El Mundo Clásico I don't. I'm not familiar with him, but I know only he deal with the classical science. So it was a very interesting information for me or for our colleagues related to the legal history or the comparative legal history. So thank you for it. Where did you find the information, August?
Well, I was trying to find links between Hungary and Argentina. So
thank you very much. It is
because I
very,
thought
very, very kind of you.
I thought it was suitable. So I started to do research, and then I came across his name in a footnote. And then once I had the name, then I was able to Google him, and then many things appeared thanks to Google. And among one of those things that appeared is the speech when he was inducted into the academy in Argentina. And that's the one that I cited. It's in Spanish, but it can be easily translated with Google Docs, I guess. And they mentioned your university, and I thought it was extremely special. So I put it forward. I see Viviana has her hand.
Yes, Viviana,
please. Yes. In line to what Agustin is asking also, I'd like to know if you can recall any cases like the one that Jose spoke about, this Italian professor Finzi, who emigrated to Cordoba. If you can recall any Hungarian professors that had to emigrate because of Nazism.
Mate?
I don't know.
I don't know. For example, in the legal history, we don't know. Maybe I haven't have not any information about this, but maybe we will check it. So if you organize another meeting in the near future, I will pay attention to this question, but I don't know, Viviana. So
okay, I didn't want to.
I haven't got any. I'm thinking about our legal historians, but we haven't got any problem after the Second World War with the legal historians. I think maybe the little situation, but not the same situation after the Hungarian Revolution in the middle of the 19th century, 1956. Some legal historians move out from the university, but for example, move out to the archive. Not the same, but a little bit maybe a connection. For example, some Hungarian legal historians step down the cathedra and have to move the archive to work on her or his research topic after the revolution, but it was only a political decision related to some participants' success.
I know some historians, but lawyers not, who immigrated in United States or
Yes, mainly the United States. For example, John Lukács is an outstanding Hungarian-American legal historian.
Okay, so it's an interesting starting point for for research.
Yes, starting point and the common point. Yes, exactly.
Yeah, and maybe we could take this opportunity to mention what is happening now in Argentina. We have two main institutes of legal history, one in Buenos Aires and one in Cordoba. So I mentioned this in the event that you do find any traces that you want to follow, so any actors that you want to follow across the Atlantic, you can approach, of course, you can approach us naturally, but also do know that there are, those are the two powerhouses, Buenos Aires and Cordoba. And people like Jose Daniel Cesano have been working a lot in tracing this movement of emigres. And we had many populations that came to Argentina in different times. And we, of course, also had Hungarians. So I wouldn't be surprised that this case that I mentioned is not an exception. I'm sure there will be other, because we call it the chains of migration. Most probably this Hungarian colleague, when he was in Argentina, he must have been eating some rich Hungarian food with other Hungarians that were living in Buenos Aires or in Cordoba, wherever it would be. I know that he studied a lot, or he collaborated a lot also with the people from the northeast of Argentina. That's what the document says. So maybe he has contacts, or he had contacts up north.
I see. Maybe in the near future, I would be very happy if we travel to Argentina. So maybe some Hungarian legal historians will be participating. For example, Argentine University, of course, only a short time, but it was only a possibility. Yeah. Okay. Dear Viviana, you mentioned. Maybe the same way what happened in the adaptation of foreign institution in Argentina. If we examine, for example, the Hungarian codification process in the 19th century, views or adopted sometimes the same legal institution. For example, we focus in the 19th century the Austrian or the French codification. What about the situation, Viviana, in the 20th century? Because the Hungary codificators changed the mind to the Austrian model to the German model. So what is the situation in Argentina in the 19th century?
Well, I spoke about the situation in the 19th century because these dissertations.
Sorry. If I said 19th, it's okay. The 20th century.
Okay. I've researched only the first years of the 12th century, but I think that later on students did not stick so much to the influence of the legislations and the authors that had been cited by the codifier. And for example, regarding civil law, they started to see, for example, the Italian models and the Italian doctrine more than those of France. It depends on the area, right? For example, regarding commercial law, I can see. I did not speak about theses that were about commercial law in this presentation, but I studied that subject in an article that is in print right now. And regarding commercial law, there's a strong influence of French commercialists, French authors, at least during the first half of the 20th century. I don't know if I could answer your question.
Yes, of course, because it is very interesting situation in Hungary. In the 19th century, we basically followed the Austrian way, and the 20th century, after the turn of the century, we followed the German codification because the German BGB is set up. So it is very interesting. Thank you for this information. Augustin?
Yes, thank you. I was planning to, and stop me if this is not the case, but I was planning to dialogue with Viviana. Can I do that about the topic that you just asked Norbert to add on what Viviana said? Can I do that? Can I add Norbert? Yeah, I see your face here. So thank you. So I wanted to add that Argentina will work on the revision of the civil code starting in the 20s. And that project that will never be adopted was also looking at the BGB. So it was similar to what Hungary did, that they moved But then they were never adopted the new code. The new code would only be adopted in 2015. So indeed, what happened is that during the entire century, they were looking to other places, like Viviana said. But in practice, the code, the big structure was still the same, with a few changes here and there. And the most changes will be in the second half of the 20th century. And then in criminal law, it also happened something very interesting, that the German ideas also started to percolate into academia. And then many of the criminal law professors would be, especially in the last decades, very much acquainted with the German developments and would study in Germany and then come back or translate German books into Spanish. So it's like Viviana said, indeed, there's a lot of diversity depending on the area.
Okay, thank you. Thank you very much. Mate?
I have a question to Augustine and Viviana. Why did the Argentine codificators follow the French model? Maybe the French language, they can they can translate the legal concept from French to Spanish easily. The languages. Yeah.
I can answer partially your question. I guess because the Argentinians were very familiar with the French code, and because it was well known at that time, and probably also because of the language.
Mhm.
Agustin?
Yes, thank you, Viviana and Mate. I wanted to add that it was a successful model that had worked, and there was a need to codify.
Mhm.
So they took that model, but they didn't take it blindly. And that's where the studies by Alejandro Guzmán Brito show that indeed there was also a lot of local influence. So generally, when you look from outside, you look into Argentina, for example, you would say, oh yeah, they have the French code. But we have a code that builds on the French, but that has strong elements from drafts made by Andrés Bello for Chile, Teixeira de Freitas for Brazil, even the Louisiana Civil Code, that they also followed the French model, but they adapted it. And then the codifier in Argentina said, wow, let's use Louisiana, because they had been a Spanish territory. They used the French code, and it worked. So it was what in the theory of legal transplants can be called the successful transplant. You take a model that works, you adapt it, and you make it your own by adapting to your needs.
Okay,
That's my answer.
Mhm. Thank you very much. And the last one is, please, Jose Daniel Castano, professor.
Thank you very much. I would like to mention first regarding Colonel Sultan Mehetz. He was inducted into the Academy of Moral and Political Science, lecturing on Introduction to Pythagorean Ethics, and was presented by the historian Enrique de Gandia. The second point relates to Córdoba thesis during the late the period what estamos war trade, while there are often citations of foreign laws or doctrines. These citations were merely for scholarly purpose. There were no comparative analysis, as Martin del Paz will teach. This all.
Yeah. Thank you. Thank you very much. And I think we close this section and continue with the Hungarian presentation. So, Viviana, please leading this next section.
so shall we start right now?
Yes, of course.
Okay, great, great. So we have 3 presentations right now. The first one will be that of Mate. I don't know if I'm pronouncing it correctly. Mate Petervari, who is a senior lecturer, who will deal with relationship of bankruptcy procedure and compulsory non-bankruptcy settlement in Hungary and Austria in the first half of the 20th century. Mate, the floor is yours. You have 20 minutes. We can't listen to you.
Nem hallunk.
Not now.
Igen,
Okay.
most már jobb.
Thank you.
Okay, go ahead. Go ahead.
I try to share my presentation. And now, does it work? Okay. Thank you.
Okay.
And okay, I can start my presentation. Thank you for the introduction. I feel a great gratitude that I can participate in this scientific event with Argentine colleagues. Now I would like to start with my title of my presentation. I would like to explain it. I am researching the history of the Hungarian bankruptcy law since receiving my PhD. The title of my today's lecture is The Relationship of Bankruptcy Procedure and Compulsory Non-Bankruptcy Settlement in Hungary and Austria in the first half of the 20th century. In my lecture, I intend to present the relations between bankruptcy procedure and compulsory non-bankruptcy settlement in Hungary and in Austria in the interval period. Besides, I will compare the Hungarian rules with Austrian bankruptcy code of 1914, which firstly introduced compulsory non-bankruptcy settlement in Central and Eastern Europe. I have chosen these foreign regulations because the Hungarian legislator relied on them as models during the codification process. In addition, I will examine practice of this question as a law in action approach can demonstrate how the legislators' intent was implemented. To this end, I will analyze transition between 2 insolvency procedures based on archival sources from the Bács-Kiskun County archives of the Hungarian National Archives. This material allowed me to examine 15 years of practice during the interval period, enabling me to present the legal practice on the basis of a representative sample. And on this slide, we can see the structure of my lecture. Firstly, I would like to briefly present Hungary and the Hungarian history in the interval period until the end of 1920s, because it was my examined period. In the second part of my lecture, I would like to demonstrate the reason of my comparison between the Austrian and Hungarian regulation through the historical development of insolvency law in these 2 states. In the next part of my lecture, I will compare the Hungarian and Austrian regulation concerning the transition to types of procedures. In the last part of my lecture, I will sketch the methodology of my research, which based on working up of documents of the Royal Regional Court of Kalocsa, and I would like to make known the results of my research. Firstly, I would like to characterize the examined country, Hungary, in this period. Hungary is situated in East Central Europe from 1867 to the end of the First World War Hungary was a member state of the Austro-Hungarian monarchy. It was a member state, but the legal system and legislature were independent of Austria. Thanks to the First World War, the political situation has also changed. The Hungarian king, Charles IV, laid down the management of governmental cases in the proclamation of Eckhardt-Sau on 13th of November 1918, which was interpreted by the Hungarian political circles as abdication of the throne. For this reason, the form of state of Hungary had to be changed, and the People's Republic was proclaimed on 16th of November 1918. However, this political system was ephemeral because the Hungarian Party of Communists grabbed the political control in March of 1919, and they established the Soviet Republic instead of People's Republic in Hungary. However, later the Hungarian Soviet Republic failed because of the Romanian invasion of Hungary on 1st of August 1919. The Hungarian political system was restored in 1920, which meant the beginning of the Horthy era. The Hungarian political elite leaned on the historical traditions, therefore Hungary became kingdom again. On the contrary, the Habsburg Emperor was not able to return to the throne, thus the form of state was a kingdom without king. The head of state was the governor who replaced the king. The Hungarian governor was Miklós Horthy, thus the historians indicate the era from 1920 to 1944 with his name. We can see him on the left picture. The Act 1st of 1920 on the restoration of constitutionality and temporary settlement of the exercise of state power regulated the legal status and authorities of governor. The most significant politician of the 1920s in Hungary was István Bethlen, who was able to stabilize the Hungarian political system as a prime minister. He filled 10 years in this position from 1921 to 1931. We can see him on the right picture. Secondly, I want to provide an explanation for the comparison. Hungary had strong connection with the Habsburg Empire from the 16th century, which connection was precisely regulated by the Austro-Hungarian Compromise in 1867. This yellow area was Hungary, and the brown area was Austria. The whole state was the Austro-Hungarian monarchy, which was established by the Austro-Hungarian Compromise in 1867. Hungary was an independent state in this state formation, with independent legislation, execution, and judiciary, but the two states had common affairs and they had strong economic relationship. Therefore, Austrian law influenced the Hungarian legislation and economic law. Austro-Hungarian monarchy remained until the First World War. This period is called dualism in the Hungarian history. We can observe a strong relationship between Austria and Hungary in terms of economic law, particularly in the area of bankruptcy law. It was a classical insolvency procedure. The aim of this process was to divide the bankrupt estate among creditors based on equal principles. A very important feature of this insolvency process was it could be started against private person and or commercial companies. Therefore, the act distinguished ordinary and commercial bankruptcy. The bankruptcy law was recodified in Austria in 1868, which was a modern regulation in Europe. For this reason, István Apáti, a Hungarian university professor of commercial law, created draft law on bankruptcy on the basis of Austrian Bankruptcy Code of 1868 and the German Bankruptcy Code of 1877. This draft was adopted by the Hungarian National Assembly in 1881, which followed Austrian regulation in many aspects. After long preparations during the First World War in 1914, a unified insolvency law has been established by an act in Austria, which included new bankruptcy law and regulated right of rescission and compulsory non-bankruptcy settlement. In Hungary, the government introduced the compulsory non-bankruptcy settlement by a decree of Prime Minister in the shadow of the First World War. In these decrees, the bankruptcy procedures which were started by creditors were suspended, and the creditors were not able to initiate new bankruptcy procedures in this period. The Hungarian government maintained the moratorium of bankruptcy procedure until 1915. At the ministry, the councillors sought the solution to order the economic relations because the Hungarian political elite recognized if they had immediately restored the effect of Bankruptcy Act, it would have caused an economic shock. For this reason, they established the compulsory non-bankruptcy settlement in Hungary, and the moratorium of the bankruptcy procedures was seized simultaneously with entering into force of the new institution. The government hoped that the merchants and the firms who had got financial difficulties because of the war could escape based on the new regulation. We can see that Austria and Hungary almost simultaneously compulsory non-bankruptcy settlement. Therefore, I supposed that the two lawmakings had an impact on each other. This is the reason of my comparison. The procedure is basically similar in both cases. The substance of the compulsory non-bankruptcy settlement was that the creditors remitted a part of their claims or they gave the debtor a delay for the pay. In this way, the debtor was able to avoid the bankruptcy procedure and its adverse legal consequences. He was able to initiate the procedure with the submission of the compromise offer. If the majority of creditors supported the compromise offer, the court could strengthen the agreement which obliged the minority of the creditors who were opposed the agreement. This institution was able to be a more beneficial procedure for the creditors than the bankruptcy procedure, even though they lost a part of their claims at the end, because with the help of the bankruptcy procedure, they very often got just a small part of their claims, and it took a lot of time. For this reason, the aim in Austria and Hungary with the compulsory non-bankruptcy settlement was the more efficient satisfaction of the creditors than in the bankruptcy procedure in general, to help the debtor to remain an active economic actor despite his financial difficulties. We can see big difference in the introduction in Austria and in Hungary. The legislator reformed the whole insolvency law with the introduction of the new insolvency procedure in Austria, but in Hungary, the bankruptcy law from 1881 remained unchanged. Therefore, the coherence between two insolvency procedures was missed in the interval period. Another important element in the two lawmakings, Austria regulated the compulsory non-bankruptcy settlement by an imperial decree, and in Hungary it was regulated by a decree too. This new insolvency procedure allowed broad intervention in the private laws of individuals, which the Hungarian National Assembly has to regulate by an act according to the Hungarian constitutional rules. But the Hungarian legislator only partially solved this problem because the procedure has not been regulated in detail by law. The Hungarian National Assembly gave itself the authorization to regulate this question by decree according to Act 5 of 1916. Because of this parallel legal development, I have chosen the comparison of these two regulations, but I can realize a deep examination only one segment of these procedures in today's lecture. Because of this, my narrower topic in my lecture is the transition between the types of proceedings between the bankruptcy procedure and compulsory non-bankruptcy settlement. On this slide, I can show you the affected legal rules. The scientific literature in Hungary and Austria said that compulsory non-bankruptcy settlement was primary procedure as opposed to bankruptcy proceedings because it was more beneficial for debtor and creditors. We can see this in the first legal regulation in both columns of the slide. The debtor can start compulsory non-bankruptcy settlement if the conditions of the opening of bankruptcy procedure are fulfilled. We can clearly see this in the Austrian regulation, but the Hungarian regulation is the same, only detailed because in the first part of provision we can find the condition of ordinary bankruptcy, and in the second part the condition of commercial bankruptcy. The difference is not so surprising because the commercial bankruptcy procedure was regulated by Austrian bankruptcy code of 1868, but the new code in 1914 eliminated the difference between commercial and ordinary bankruptcy procedures. The second legal provisions regulated the transition from compulsory non-bankruptcy settlement to bankruptcy procedure. In both cases, if the court terminated the compulsory non-bankruptcy settlement, the procedure can continue with bankruptcy procedure. But we can see a big difference. In Austria, only the debtor or creditors can initiate bankruptcy procedures, but in Hungary, the court can open bankruptcy proceedings ex officio if the debtor is a merchant. The debtor is not a merchant. The regulation works in the same way like the Austrian rules. The creditors can file a petition to open bankruptcy proceedings. We can determine that two regulations were very similar. The reason of difference was only the different bankruptcy law regulation. Hungarian codificator adjusted the Austrian legal provision to the Hungarian bankruptcy circumstances, but new solution was the opening of bankruptcy procedure by the court ex officio. And finally, I would like to present my research in the archive, which can demonstrate the legal practice of the relations of two insolvency procedures in Hungary. First, I would like to describe the methodology. I analyzed the judicial practice of the Royal Regional Court of Kalocsa. The city is situated in Pest-Pilis-Solt-Kiskun County in central Hungary. This map showed this county, and we can see Kalocsa within the green frame. And we can see within the red frame the most famous Hungarian city, the capital, Budapest. We can say that Kalocsa is situated near Budapest. I would like to continue with the Royal Regional Court of Kalocsa. We can see the Hungarian jurisdictional structure of this age on this illustration. I described the Royal Regional Court within the green frame. The Royal Regional Court was the second level in the Hungarian jurisdictional system, but it was the first instance in the compulsory non-bankruptcy settlement procedure and bankruptcy procedure. I chose the Royal Regional Court of Kalocsa because the documents of this court survived fully. Thus, we can examine bankruptcy procedures and compulsory non-bankruptcy settlement in many cases. On the next slide, we can see the distribution of insolvency cases in the examined period. I found 150 insolvency cases, and 5/6 of the total cases was compulsory non-bankruptcy settlement. Thus, new procedure dominated the insolvency cases in this period in Hungary. I identified only 24 bankruptcy cases. Therefore, we can say it was only a supplementary tool for insolvent debtors. And the next slide, I would like to speak about my research achievements concerning the transition between two procedures. I identified 8 cases in which the court continued the proceedings with bankruptcy procedure after termination of compulsory non-bankruptcy settlement, and the court acted ex officio only in 1 case. It is very rarely. This case was the case against Sándor Varga. I copied the documents of this procedure on this slide. He was a merchant, therefore the court had right to open bankruptcy procedure ex officio, but the court could easily determine his profession since the debtor declared his merchant before the court. And finally, to conclude, Hungarian regulation of compulsory non-bankruptcy settlement followed the Austrian regulation with minor changes. The compulsory non-bankruptcy settlement took over the main role from bankruptcy procedure in insolvency cases in the interwar period, and the transition between the 2 types of procedures was not so often, but we can find some examples. Thank you for your attention.
Thank you, Mate. Thank you for sticking to the time. And excuse me, Norbert, because I made a mistake of giving the floor to Mate, because I was looking at the abstract that you had sent me, and Mate was the first one. And so I didn't have a look at the schedule. So excuse me very much. So thank you, Mate. Can you stop sharing the screen, please? Okay.
Okay, can you see my presentation?
No, because I think, okay, yeah. Okay, so Norbert, the floor is yours.
Thank you very much. So we would like to speak about today, Mate, Benedek and me, a joint project developed by the Hungarian ministry. So this is by the reason we use the same PowerPoint presentation, and we discuss the same legal topics, issues between the 2 world wars. This is the new research topic related to my department. So today I will speak about the European background of the Hungarian cartel law, legal transplant of domestic legislation. I would like to explain in my presentation how developed the Hungarian cartel law in the wave of the European codification movement. The main point, I think the main point of the cartel movement in the 20th century can be found in the contradiction, of course, the pre-competition, since the pre-competition resulted the measures restricting fair competition, which could only be combated by guaranteeing the free competition in the interest of the consumers. The Act 20 of 1931, the Hungarian cartel law, implemented the Hungarian antitrust regulation, essentially regulated the cartel law, which was fundamentally cartel public law, of course, for us, in Hungary as part of the European codification process, in which state intervention and the protection of the public interest played the primary role. The unified regulation of the cartel private law was never established in Hungary. In its absence, the general rules of private law of Hungary, particularly the commercial law, served as a standard reference for the applications of law. European cartel rules first emerged in the 19th and the 20th century. As part of this wave of codification, the Hungarian Act, the Hungarian Antitrust Regulation, was also adopted in 1931. The regulation of cartels changed in the light of the economic and, of course, beside the economic, the political condition of that time. There was a fundamental difference between American and the European approach to the cartels, to the antitrust regulation. The American way of thinking and the legal understanding viewed the cartels and trust unfavorably, which led to the Sherman Act of 1890 and later to the Clayton Act in 1940. The similar provision were enacted in Canada 1889. However, the regulatory process in Europe was different. The judicial practice basically regarded the cartel agreements as contrary to the good morals. The role of the judicial practice should be mentioned, of course, here. In absence of the statutory regulation, it was primarily the practice of the Supreme Court of Hungary, the Curia, determined the development of the law, which is not surprising, of course, in the context of the Hungarian private law. But the paradigm shift in the cartel way, way of the cartels, where judges occurred after the turn of the century, particularly in the years following the First World War, when the cartels became a major feature of economic life, and the legal prohibition applied only to cartels that posed threat the economic and, beside the economic, the public interest. The state considered it necessary introduce the administrative rules on the cartel in adoption of private and the criminal provision. The first legal regulation of the abuse of economic power was introduced in Germany in 1923, followed by the regulation of the cartels in several countries in continental Europe, for example, Sweden in 1925, Norway and Spain in 1926, and Denmark in 1929. This was followed by the Hungarian Cartel Act of 1931. Austria was at the forefront of the cartel legislation with the introduction of the 1897 bill, but no Austrian law, cartel law, was adopted in the period under review. The archival materials of the Ministry of Commerce was destroyed in Hungary, including the material related to the codification of the cartel law. However, among the archival sources of the Ministry of Welfare and Labor, I accidentally came across the correspondence with the Ministry of Justice from 1930 related to the cartel proposal. This proposal still introduced the provision of the private law, such as the provision that the cartel agreement, contrary good morals, are null and void. This reflects the judicial practice of that time. Given the circumstances surrounding the codification of the private law at the time, it must be said that the role of the courts increased significantly during this period, particularly with regard to establish the legal certainty and the uniformity of the law. The Curia, the Hungarian Supreme Court, repeatedly attempted to address the legal problems caused by the war. In the absence of a private law code in Hungary, it felt the courts to decide the cartel cases on the basis of the existing legislation. It should be noted, however, that in case neither Act 37 of 1875, the Hungarian Commercial Act, or the Act of 67 of 1884, the Hungarian Industry Act, provided sufficient legal basis, of course, related to the Hungarian cartel law. It can be concluded that the First World War affected the private law and its codification most clearly through the state intervention. The peacetime, the state, apart from the providing the legal protection, refraining from interfering in private law relations, but in the outbreak of war brought change, of course. Intervention was necessary in the interest of the securing the state goal of the public interest, with particular regard to price regulation. An examination of the law provisions make it clear that the legislation aimed to regulate the public cartel law in Hungary in the interwar period. Its rationale lay in the introduction of the cartel supervision, indeed, the ensure that the cartels conducted economic activities serving both consumer protection and the economic interest of their members of the companies. The regulation of the private cartel law in Hungary has therefore been published into background, which is a similar result of the codification of the European cartel law, primarily the German cartel decree of 1923, where the regulation of the cartel supervisory authority also took priority. If we consider the 1926, the Norwegian regulation on the controls of restriction on competition, and for example, the price abuse, we see that the public law control over the cartel was also the dominant in the country. As Augustine said, we try to connection between Argentina and Hungary, and I do that. So I realized that in Argentina, the antitrust regulation was adopted in 1923 to following the USI trend based on the Sherman Act, so not the wave of the European codification process. In my opinion, with regard to private cartel law, it is a case law. I have sources that can be used to present the substantive elements of the cartel agreement. My current research focuses on the examination of the cartel agreement based on archive sources. Existing the literature on the cartels has not examined the private cartel law for a practical perspective. I am examining the materials of the Budapest City Archives and the economic section of the National Archives. Explains of this can be seen on this slide. The Hungarian private cartel law was not codified. So, and its content of the Hungarian private cartel law can be determined based on the practice. The Hungarian cartel law took into account a number of foreign models before the first act was adopted by the Hungarian parliament in 1931. In this respect, it should be emphasized that the Hungarian literature has followed the European legislative developments. In order to understand the development of the Hungarian law, it cannot be examined in isolation, but must be placed in the European context. The system of economic relation and the public law cooperation between two countries justified the presentation of the Austrian cartel law in the light of the Hungarian literature. The critical situation regarding the cartels was also highlighted by Friedrich Kleinbachter, Austrian economist, in his monograph published in 1883. He called the cartel the children of necessity, the Kinder der Not, and focused on the economic effects of the cartels, since the fundamental problem was whether cartels constituted an economic or legal issue. Adolf Menzel, Austrian legal scholar, then discussed the impact of the cartels on the economy. Austrian professor's proposal provoked a serious debate, after which the government prepared by 1897 the proposed new law on the cartels, with consumer goods subject to consumption taxes in close relationship with industrial production in their scope. David Gerber, professor and the president of the American Society of Comparative Law, stressed in his study that this was a bill of high professional standards which could serve as a basis for the subsequent codification work. It was the first bill for the cartel law in Europe. This was the first proposal, and according to Julius Landesberger, to take up the idea of the public cartel register. The 1897 cartel bill had a significant impact on the development of the law on cartels. Using the legal terminology of the period after the compromise between Austria and Hungary, 1867, the bill fundamentally concerned the products covered by the so-called indirect taxations, closely linked, of course, the industrial production. The process of drafting the Hungarian legislation then became almost invisible in the background of the political struggles. Sándor Hegedűs, who was a minister of trade, commissioned Zoltán Ráth, who was a professor at the Academy of Law in Košice, to prepare a study related to the cartels. However, the legislation itself was still not prepared. Subsequently, Károly Hieronymi, the next trade minister, commissioned Pál Mandel, a lawyer and a member of the parliament, to draft a bill, which was published after the turn of the century in 1904. The idea of common cartel law with Austria, as well as the creation of the common cartel office and the common cartel codes, was raised. This is, however, could not be derived from the rules of the compromise between the two countries in the terms of public law, nor could scope of common affairs could be extended. The Hungarian draft did not become a law, but it can nevertheless be considered a milestone in the codification of the Hungarian cartel law. It should be pointed out that the Hungarian draft also included the implementation of the cartel supervision. The Austrian cartel movement had a considerable impact on German cartel legislation around the turn of the century. Robert Liefman analyzed the problem of the cartels from the economic point of view, which special attention paid to the realization of the freedom of competition. The first piece of legislation on cartels issued in Europe was a German decree in 1923, which was relied on by several European countries, among others Hungary too, when the legislation on cartels was drafted. The German decree, defined what a cartel is, when a cartel agreement was null and void, when the operation of the cartels endangered the interest of public economy and the common good. Decree also regulated the rules and responsibilities of the Imperial Minister of Commerce concerning the supervisions of cartels. The decree ordered the setting up the most important cartel supervisory board, that is the cartel court. That was the cartel court. Subsequently, on the 26th July 1930, the emergency decree on cartels was passed, impede the price fixing that determined public economy in Germany. The so-called Emergency Cartel Act of 1933 granted the German Minister of Commerce to right to gather companies into a cartels after considering public interest. In connection to this topic, the so-called Compulsory Cartel Act of 1933 is the next somewhat relevant step, which served as closure to foundation of the development of the German cartel law in the first half of the 20th century. Back in the 1923, the cartel decree meant the defense. However, in the 1932, after the Hungarian Cartel Act, they changed about and issued the compulsory formation of the cartels. We can say that the Hungarian government established the supervisory public authorities that greatly influenced the operation of the cartels. We can have observed the same situation in Europe when the state regulated the cartels. The Hungarian legislators attention was paid to the Austrian and German cartel regulation. This is the reason why the Cartel Court and the Cartel Committee was adopted the most significant factors in the cartel cases in the 19th century in Europe, of course, in Hungary too. The emergence of the cartels can be dated to the 19th century, the period when various forms of cooperation between companies appeared as a result of the free competition. The law sought to respond the new phenomenon by using existing the instruments of the private and, of course, beside the private, the commercial law to deal with the problems of everyday life. However, the general principles of the private law did not provide a sufficient basis for the regulating cartels, as a result of which the need for regulation arose in many European countries in the 19th or 20th century. The codification of the cartel law was significantly influenced by the economic policy regime of the cartels, which was closely linked to the customs unions of the Austrian-Hungarian monarchy following the compromise of the 1867. The Austrian codification of the cartel law and subsequently the Hungarian legislation was an integral part of the development of the contemporary continental cartel law, which resulted in the implementation of an ever-increasing state control over the cartels. The legislative achievements related to the Austrian and German cartel law have played a significant role in the development of the Hungarian cartel law. Hungarian legislation follow the regulatory of the Austrians who sought to regulate the cartels in the separate act in 1897. As a result of this process, established the state supervision. Hungarian and Austrian law propose almost identical solution. The Hungarian government did regulate the institution of the cartel supervision in the public interest, of course, in the beginning of the 20th century, in course of which it took into account the European case law and the legal developments. Thank you for your attention.
Thank you, Dr. Varga, for your presentation. Thank you for sticking to the time. And now I'm going to give the floor to Benedek Varga, who is a PhD student and who will address the topic of a question. Necessity makes the law. The impact of World War I on criminal legislation and dogmatics in Austrian, German, and Hungarian legal department. Benedek, the floor is yours.
Thank you very much. Thank you for the word. One moment, and I'm trying to share my presentation here. Okay. Do you see my presentation now?
Not yet. Right now,
yet.
Yeah,
Okay.
go ahead. Yeah.
Thank you very much, ladies and gentlemen. Thank you for the word and the opportunity to present my researches here. My PhD mainly focuses on the development of economic crimes in Hungary, the historical development of economic crimes. But in the 2 days lecture, I've chosen a more general topic. The sentence "necessity breaks or makes the law" comes from one of the most influential, one of the most outstanding Hungarian legal scholar Ferenc Finkei, who said that the emergency situation in a country, for example, a war, could not only suspend the normal lawmaking, but creating new dogmatic categories. So in the first part of my lecture, I'm going to speak about the codification techniques in comparison with Austria, Germany, and Hungary. After that, I'm going to focus on the main dogmatic changes of the general part, especially the question of the error in law and the mistake in law. And finally, I'm going to speak about the special part question, focusing on one economic crime. We can say that in the second part of the 19th century,
Benedict, sorry, we can see only the editor mode. Okay.
Now,
Perfect.
maybe?
Yeah, okay. Perfect.
Okay, thank you. Okay, so in the second part of the 19th century, both...
Excuse me, Benedict. If you click to the, how do you say, the glass that is in the
This
upper
one?
part, no. Agustín, ¿cómo se llama la copita esa que está abajo
We can see only the editor
yeah,
mode.
yeah, we can see, or I see it is on the left side up or on the right side down.
Maybe,
yeah, that one. We can see
It will be the slideshow.
Yeah.
Viviana is referring to the slideshow.
F5.
F5.
Share
Jeremy
your...
is F5.
Maybe now?
No?
No.
Not yet.
Okay, sorry.
But it's on its way.
I
If
press
not, it's
F5, it doesn't really work.
Maybe this is the problem that you chose the
the wrong option here.
This window.
Okay.
And you have to choose the whole screen.
Okay.
Share.
Choose another option because it's editorial mode.
Maybe now?
Yes,
Yeah, it will
not
be
exactly because you share your our.
Okay. Yeah. And now you
can
have
see
to...
my presentation?
No.
No. What's the problem?
We see the Google Chrome.
Okay.
If not, it's okay. Sorry for interrupting you.
No problem. Can you see it now?
No.
Not yet.
Not exactly. We will see your Facebook picture.
Or or the Google picture.
Okay, don't worry, Benedict. Don't worry.
I try another thing.
Okay.
You have to share the whole screen and start the presentation in your screen. This is the solution, maybe.
Maybe now? I share my whole screen.
Yes. Okay. And now you have to start.
Perfect.
Okay. Thank you very much. Sorry, I'm really unfamiliar with this with this program. Okay, so let's continue. In the second part of the 19th century, both in Austria, Germany, and Hungary had a criminal code. In Austria, the criminal code of 1952. In Germany, the so-called Reichsstrafgesetzbuch, the imperial penal code. And in Hungary, the first criminal code, the so-called Kócsemegi, which was followed the triatomos system of the Code Penal, so divided the crimes into three main categories: the crime, the misdemeanor, and the contravention. But after and during the First World War, we can see the expansion and the acceleration of the Nebenstrafrecht regulatory model, which means that the criminal provisions appeared in separate side acts. What was the cause of that? The famous German legal scholar Klaus Tiedemann explained it by two factors. The first one is the dependence of criminal law norms on extra criminal regulations, for example, in case of tax law and tax criminal law. And the second factor, when the legislator intends to keep the criminal offense in force only for a limited period of time. Let me give you an example. For example, the Act 9 of 1916 about overpricing misdemeanors was in force only for wartime, so the temporal scope of the act was limited. But we have to emphasize that the regulatory model of Nebenstrafrecht is not specifically a product of wartime legislation. Its expansion had already begun earlier, particularly in Germany and Austria. For example, in Germany, the different fraudulent and culpable bankruptcy conducts were regulated by the Konkursordnung, or in Austria, the crime of usury or military crimes were regulated by the Waffenpatent and the Wuchergesetz. Basically, we can say that these were endangerment offenses, in German, the Gefährdungsdelikte, and morally neutral norms. This is particularly true for the economic crimes. What can we tell about the question of extraordinary authorization? The emergency situation, because of the emergency situation, the different bodies of the executive power got an authorization in these countries to issue contra legem decrees, which had effect in criminal legislation too. In Hungary, before the First World War, the government got an exceptional power to take measures in case of war. We can say that primarily contraventions were criminalized by the way of these decrees, especially offenses committed against the army and its supply system. Secondly, we can say that the decree regulation was more significant in the field of procedure law rather than substantive law, and mainly aimed at accelerating of criminal proceedings. And thirdly, the new type of crimes, for example, the overpricing misdemeanors, the misuses of payment instruments, the tax fraud, and things like that, were regulated by side acts, but not by decrees. In Germany, we can call this era the so-called Interventionistisches Bewirtschaftungszwangsrecht, named by Hans Achenbach, a famous German criminal scholar, and we can translate it as interventionist economic coercive law. And during this era, the Bundesrat got an authorization to issue contra legem decrees in order to mitigate economic damage. In order to rapid response to economic changes, the Bundesrat created framework offenses, blanket delicts, which was filled by content by other organs of the executive power, for example, the imperial chancellor, state authorities, or military commanders. Let me tell you an example. For example, in case of overpricing misdemeanors, the blanket delict was filled by the measures of state authorities, which determine the maximum prices of different public necessities. In Austria, the situation was similar, but a little bit different, because there was a double authorization. First of all, the emperors had the right, according to the constitution, to issue emergency decrees, but in the second year of the war, the government also got a war economy authorization to issue the necessary orders to promote economic activity, particularly in agriculture, industry, commerce, and trade. And the government issued several contra legem decrees, mainly in the field of contraventions. However, these referred to criminal sanctions, for example, fines, and for example, to prison sanctions. The codification technique had effect to the general part of the criminal code, mainly to the question of error in criminal law provisions. First of all, we have to emphasize that both Code Csemegi and Reichsstrafgesetzbuch according to Csemegi and Strafgesetz's book, the mistake, the error in criminal law provisions was irrelevant. So it didn't exclude the criminal liability. But after the expansion of the Nebenstrafrecht and especially the blanket norms, the legislator had to react to this situation because the criminal law has lost its norm-orienting function, which has been particularly disadvantageous for economic actors due to the constantly changing regulations of economic law. So the legislator had to follow the nemo potestat impossibili obligari principle from Roman law, so no one can be obliged to fulfill something which is impossible. Consequently, the legislator had to create exception rules under the principle of ignorantia juris nocet. In Germany, the Reichsgericht concluded in connection with Blankenstrafgesetz that the legal provisions, instructions, and other measures intended to supplement the open criminal provisions, so the blanket norms, do not become part of the criminal law. Consequently, an error regarding them is considered a non-criminal mistake, so it excludes the liability. In the second year of the First World War, the Bundesrat created the so-called Rechtsirrtumverordnung, which explicitly broke through the principle of ignorantia juris nocet, because said that the non-culpable mistake regarding the existence or applicability of a provision of a criminal law constitute a ground excluding punishability. The Hungarian situation was completely different, because the Royal Hungarian Curia concluded that the norms filling the framework became the part of the criminal provision. Therefore, it is merging with the criminal provision, so it didn't exclude the criminal liability. Contrary to the Delega Ferenda commissions of the legal scholars, there was no special regulation to mistake error in Hungarian criminal law, unfortunately. And after the general part, I would like to speak about the economic crimes a little, because this is the era, the First World War and the interwar period, when the modern economic crimes were born. And especially I would like to speak about the so-called overpricing misdemeanors. In a normal situation, prices are determined by the supply and the demand, but in the time of the First World War, the legislator broke through the laissez-faire principle and intervened into the economy to criminalize certain conducts in connection with overpricing. And let's see the German model firstly. In Germany, the Verordnung gegen Preistreiberei regulated the main forms of overpricing misdemeanors, and the first and most important one was the so-called price usury, or in German, the Preiswucher, including setting or accepting such prices for public necessities, which include unfair or excessive profits. The second most important was an interesting crime, the chain trading, or in German, the Kettenhandel, when an economically unjustified intermediary element inserted between producer and consumer, artificially and fraudulently increasing a price of a public necessity. And the third one was the overpricing delict, or Höchpreisdelikte, which means when someone exceeding the maximum price set by the authorities. We have to highlight that the rules of the error decree, Rechtsirrtumverordnung, were applicable because the criminal decree, the Verordnung gegen Preistreiberei, was issued on the basis of the Ermächtigungsgesetz, so the Authorization Act. In Austria, first of all, so in the beginning of the First World War, the overpricing misdemeanors were regulated by imperial decrees, but after the First World War, in 1920, the National Assembly incorporated all of these imperial decrees to a separate act. And it was an interesting difference from the German model, that the scope of the perpetration object was broader. Not only the public necessities were the perpetration objects, but the essential services too. but the statutory definitions mostly corresponded with the German regulation. And what about the Hungarian model? The Hungarian legislator mainly followed the German and Austrian legislation. The legislator incorporated the definitional element of public necessity. It was the common perpetration object of these crimes. But I have to emphasize that a specific statutory definition was born in Hungary, which was the overpricing stock hoarding. It was one type of overpricing misdemeanor, which was committed by anyone who acquired public necessities exceeding their household or economic needs. Because of the criminalization of economic crimes, a new type of definitional elements appeared in the field of criminal law, which was completely unknown to the dogmatics before the First World War. I divided them into two main categories. The first is the definitional elements which have economic rather than legal nature, and the second one, the definitional elements which derive from a non-criminal legal field. In connection with the definitional elements which have economic rather than legal nature, we have to highlight the public necessity, which had an unclear conceptual framework contrary to the decision of the Royal Hungarian Curia. The public necessity is an economic definition, not a strict criminal law definition. As you can see, the Curia concluded that all of those goods that a person of an average cultural level may use under normal circumstances, regardless of social status, education, or financial circumstances, belong to this category, but is so problematic because of the nullum crimen sine lega et certa principle, because it's not a strict legal definition. And now I would like to show cases, archival cases from the wartime practice. I'm conducting research in the capital of Hungary, in Budapest. There is a picture about the Budapest City Archives. And now I would like to present how the courts interpreted the intermediation, the perpetration activity of the so-called Kettenhandel, the chain trading. What was the purpose of the with the criminalization of chain trading? The purpose of the legislator was to eliminate the chain trade. The commodity intermediation in itself didn't carry any kind of social danger, since the good had to reach the consumer from the producer by some means. The problem arises when, without any economic justification or purpose, the goods pass through the hands of several persons because it is artificially and fraudulently increasing the prices. In the case of Nathan Marmor, defendant was a window dresser whom the store owner had entrusted with selling damask fabric. And at the time of the perpetration of the offense, damask fabric was an exceptionally sought after good, and the Royal Regional Court of Budapest concluded that the perpetrator's intent had to cover the fact that the resale of the goods through intermediation served solely the purpose of incorporating the brokerage fee into the price of the damask linen. And the Royal Regional Court finally said that thus the defendant conduct couldn't have served any legitimate economic purpose, only artificially increasing the price. We can say the same, not the same, but a similar situation in the case of Benaroya Behor, who was a merchant. His intermediation activity consisting in arranging for the transportation of 70 crates of matches from Budapest to Vienna, but there was no evidence to support the fact that the brokerage transaction, the intermediation, was conducted for a commission or free of charge. The Royal Regional Court of Budapest, so the first instance court, said that this latter fact is irrelevant. The court established the defendant's guilt. But the second instance court, the Royal Regional Court of Appeal of Budapest, concluded that the definitional element of intermediation implicitly includes the profit-driven intent. Consequently, it is not irrelevant that the perpetrator committed this conduct for commission or free of charge and made an acquittal. The court made an acquittal. And Previously, I said that in Hungarian legal system there was no special provision to the mistake in criminal law norms, but there was an interesting situation in lower court practice during the wartime, because the overpricing misdemeanor, the overpricing stock hoarding, was not punishable if the perpetrator had an official authorization from the competent authority. But there was a very serious omission of the legislator, because the legislator failed to specify which authority had the competence to issue this permit. And merchants believed that the simple trade license was equivalent to an official permit. So they were mistaken, and the main question, how should we assess the offender's mistake in case of a legislative omission? And the Royal Regional Court of Appeal in Budapest and the Royal Regional Court of Appeal of Szeged created the so-called doctrine of mistaking good faith, bona fide, according to which the source of their error was the belief that in the absence of the statutory regulations, a trade license that had actually been issued was considered an official permit. And the question may arise when the perpetrator considered to be acting in good faith, but historical facts should be assessed by the courts. First of all, the fulfillment of the duty to inform oneself and the examination of personal circumstances. And now I would like to conclude my the main point of my presentation. First of all, the codification technique, the Nebenstrafrecht, revealed both in Austria, Germany, and in Hungary, as well as the blanket delicts. We can say that the crimes criminalized by decree, for example, the overpricing misdemeanors, the tax fraud, remained in force even after the war ended, but of course, the authorization was terminated. We can see an interesting shift in the dogmatic approach of the assessment of error, a different approach revealed in Hungary and Germany, as I show in connection with the practice of the Reichsgericht and Hungarian Royal Curia. And from the perspective of the specific crimes, this era marks the genesis of the economic crimes, the so-called Wirtschaftsdelikte and Wirtschaftsstrafrecht. And thank you very much for your attention.
Thank you, Benedict. Thank you very much also for sticking to the time. And now we open this 10 minutes for questions and commentaries. Just raise your hand or open your microphone. Agustin, go ahead.
Yes, thank you. Thank you to all the speakers. First of all, I found remarkable how some things are recurrent, no? And now in the current context that we have with the crisis with Iran and the conflict, and how situations are being recurrent. So I think that the topic that the three of you are working, sadly, but also luckily for research, is very topical. Sadly for the reality, but good for research. And in regards to that, I had one question for Norbert, and is about were you able, Norbert, to identify any kind of messenger, a person that was the one spreading the news about this? Because I see this as a contagious, people getting contagious, but not in a negative way. So no COVID, but a positive, a contagious idea. So that's one question for Norbert. And then for Mate and for Benedict, it's a question more about the decision of the archive. In the case of Benedict, I guess the decision is maybe natural because it's Budapest, but maybe there's also another reason behind that. And in the case of Mate, I was wondering why that specific archive. And if both of you already explained that, I'm sorry that I ask again, but it doesn't harm, I think, to repeat it. Thank you.
Thank you.
Dear Augustine, can you repeat your question, because the last part I didn't understand because the line was wrong.
The question to you?
Yes.
Yes, the question to you was if you were able to find any person or institute that served as a courier, as a messenger, the one that spread the word, because indeed there was a contagious, people were getting positively infected with these ideas. How did it happen? Maybe a journal, maybe a professor, maybe an association. Thank you.
Yes, it's a very important question, but it's easy to answer it because we organized an international conference in the 19th century. International meetings, for example, related to jurists, the international jurist meetings in Germany, the Hungarian scholars participated in and discussed, for example, the economic development of the economic situation, for example, the situation of the cartels. And of course, we can read the journals, for example, the foreign journals, and of course, the Hungarian scholars, professors knows the results of the codification process. And if we examine the Hungarian journals, for example, the Cartel, it was the title of the most important journal related to my topic, we can realize that we deal with, for example, the German development, the Austrian development. I found a short essay related, for example, the Argentine development. So it is very interesting. So I found many ways to connection between the legal system in that time. And of course, there are some books and literatures, but I use basically the primary sources. It would be very interesting if I found something related to the codification process in the archive, but I found only few papers related to the codification. But it would be very useful to understand how the codificator thinking about the development of the cartels in the context of the European content, and maybe I will find something, but I don't know. Right now, I haven't any other information related to the development of the cartel law in the interval period.
Thank you very much.
Thank you. Would Mate like to add something, or Benedict, to Agustin's
Yes.
question?
Yeah. Firstly, Benedict?
Of course, yes.
Okay. Your question, thank you for the question. It was very good. Your question was why this archive material. The reason is very simple. I would like to search an archive material in which I can examine the number of insolvency cases and the whole insolvency cases, because the material survives fully. But the Hungarian archive situation is not so lucky because of due to the historical reasons, the archive material was destroyed in many archives, mainly the jurisdiction documents, the public administration documents. With the public administration documents, the situation is a little bit better, but the Hungarian jurisdiction documents was destroyed in the dualism era. I don't know the reason. Maybe the court. Yeah, maybe the courts discarded, threw out this into the rubbish these documents. Or maybe the war destroyed this, and this court and this city is not so big, and the economic work or the business life is not so big, but this is the nearest archive for me with the fully material. I try to search many other courts which had a fully archive material, but I find only two archive material, but the distance is too big. 150 kilometers or 200 kilometers from Szeged. Therefore, I chose this.
Thank you, Mate. Are these archives digitalized? They are.
No,
Right?
this archive isn't digitalized. I digitalize these cases, and I am reading these cases through pictures, because it's too many time. If I want to read this archive material in archive,
you will need your whole life. And truth is that the researchers that work on archives, in fact, we use the archives that are at hand, that are near where we live, that are with easy access, and so on. Okay, that is the truth, right? This is the same as I did with the. I worked with the archives of the city of Buenos Aires, but there is another archive, a very important archive in the province of Buenos Aires, but I do not live in the province. I live in the city. So my main source of research were the archives that were located in the city I live in. That's true. One must be honest, right? Okay, any other questions?
I have got to work. From which era do you have any archive material in Buenos Aires? From which century?
We have our main archive in the city of Buenos Aires is called Archivo General de la Nación, and I researched records of trials between families in the 18th and 19th century, and those documents are there. But there are more documents in the province of Buenos Aires at the Archivo Histórico de la Provincia de Buenos Aires, which is located in the capital of the province, not the capital of the nation, the capital of the province, that is called La Plata. And they keep there the whole archives of the Audiencia de Buenos Aires, that is to say the Supreme Tribunal that was in charge during from the 18th to the 19th century. So mostly they deal with the archives of this tribunal. And the archive in the city of Buenos Aires has, for example, more records about norms, commercial cases, criminal cases, and so on. Okay. Okay. If there are no more questions,
I would like to add, Viviana, on that. Of course, in Argentina, you cannot go way back because we have no records of Native Americans. So you start in the 16th century, and the 17th century, the institutions start to be established. So the peak is 18th century, and that's where the most documents are. And I wanted to add, again, I think Benedict wanted to react because I saw his hand.
Yes, I just want to answer your question. Thank you very much for your question, Agustin. I've chosen the courts operating in the territory of Budapest because Budapest was as the capital, the economic center of this country in this time, consequently the center of white-collar crime. And as well as I'm analyzing mainly fraudulent bankruptcies, tax frauds. It is important because most banks and firms and merchant centers are situated in this city.
Thank you
So
very much. Norbert, if you agree with me, we could move to the closing remarks of Agustin.
Yes, exactly. Augustine, the floor is yours.
Thank you very much. I made some notes when everybody was speaking, and that's why most probably you were seeing that my computer was moving a little bit. I was typing some notes. So thank you. Thank you, Norbert, for organizing this excellent event. Thank you, Viviana, for leading on the Argentine side. And thank you, every speaker, for joining today. We had two very enriching panels, in my view. On the Argentine side, we have three presentations. Viviana Kluger spoke about the circulation of ideas and legal models in university classrooms. Viviana looked at doctoral theses in University of Buenos Aires. Indeed, she showed that there was a plethora of sources, and you could see that in that drawing, that diagram that she showed. It's that indeed a comparative universe, and it's a very fertile ground. And some of those PhD dissertations have been digitalized. So it's also a fertile ground to explore from beyond Argentina. I myself looked at legal history, comparative law, and the circulation of legal ideas in Argentina towards the growth of comparative legal history. José Daniel Cesano spoke about the émigré Marcello Finzi and his contributions to the legal culture of Córdoba. Daniel offered a micro-historical study of a fundamental actor, and he followed him from his arrival to Buenos Aires, to Uruguay, all the way to his way to Córdoba, and then his visits across the globe. He explained how Finzi blended into the local environment and made extremely important contributions to the local culture. On the Hungarian side, we also had three presentations. Mate Peterbari looked at the relationship of bankruptcy procedure and compulsory non-bankruptcy settlement. Mate shared results of his very rich comparative legal historical exercise. He was able to do a dissectomy of the different cases, those cases he was able to go through. And I truly think that his approach can serve as a model for other studies that want to replicate that exercise. Norbert Berga looked at the European background of Hungarian cartel law. He offered, and I use again the word truly, he offered a truly comparative legal historical exercise in which he looked at the framework that regulates a fundamental part of commercial life. Many times we forget how important the reactions to cartels are today, in the past, and of course, it will continue being in the future. Very topical and recurrent topic. I also like that Norbert touched a little bit about Argentina, and it gave me the feeling that I would like to make it even more global and see what else was happening in other parts. So a global project. Finally, Benedict Varga looked at the impact of World War I on criminal legislation and dogmatics. And Benedict presented his work in different work packages, let's say, each of them with its own value, going from doctrinal also to empirical, or let's call it archival, because empirical now is more trendy, but the historians with archives been doing empirical work for centuries, but maybe for a grant it's easier to say that you do empirical, but okay, archival work, and you clearly addressed each of those work packages. And I especially liked the attention you gave to the fundamental legislative tool of codification. And that was indeed a topic that I think was recurrent today. Our 6 talks offered a transatlantic crash course. We all leave today with some more knowledge about the others, but also about ourselves. I think also it offered a playfield for future research and lines of collaboration. I will now use a few minutes on something that I did prepare before. These are not that's where the notes stop. Now come the notes that I prepared in advance. And these are a few action points that I would like to end with. And they relate to looking to the future. A Turkish colleague that passed away, and she was teaching in Glasgow, in Scotland for a number of years, Esin Oruku, she was a comparative lawyer, once stated that the human element is the most important. And I do embrace that notion, and I therefore invite all of us to engage in an exercise of exploring action points. The first action point relates to the need to generate synergy among actors. Let us allow legal historians to be brought together by legal history, within and beyond this event. We need to listen to old, to current, and to new voices. We need to engage with other jurisdictions and to embrace dialogue with other systems. I think that action point we're taking care of today, especially. Because I think that an upward spiral for legal history can be attained by building teams. Isolation would be detrimental for the development, producing intellectual inbreeding and then threatening the development of legal history. A second action point relates to the need to be curious and global actors. And again, I think we are embracing that. Legal history involves and evolves in many ways. Academic curiosity opens paths of exploration and ignites awareness on the needs of society. I'm sure that when Norbert looked for what was happening in Argentina in that law, it's because he was curious. He was academically curious. When Mate and Benedict go to the archive and sit there and take the train to get there, it's because they're curious, because they care. That's where the word comes from. I think that academic curiosity can take legal historians to different places in mind and in body, exposing us to other cultures and ideas. We must be open-minded and engage with otherness. A third action point relates to the need to be open and creative. Legal history will continue building and nurturing its own path, yet it should be resilient, a key word that is appearing over and over again, but that we need to embrace. Legal historians must allow themselves to be surprised by the details in the law, by the unexpected, and by the daily evolution in the life of the law. A fourth action point relates to the need to look to the future while being grateful of heritage, of the work that other legal historians have done. Legal historians need to be on top of developments, rely on new technologies, and be acquainted with the most current trends. The theme of this symposium attests for this. Yet, there is a need to cherish and protect heritage. Law is meant for a society at a certain time. The needs of society are embedded in heritage and should be protected. Let us continue making our jurisdictions spaces where legal history can grow. To conclude, we gather today to develop tools that help us understand what has happened and what is happening, and hopefully what will happen. Tools that help us to adapt to changes and needs, and that help us visualize how legal science is a fundamental pillar for law in society. On the occasion of this Argentine-Hungarian workshop, I can confidently say that all is set for new grounds and collaboration to be explored. All is set for us to continue carrying high and bright the torch of legal history. Thank you very much.
Thank you very much, dear Augustine. So, dear colleagues, finally, I would like to say thank you for the participating in our workshop, dear Viviana, Augustine, José Daniel Cassano. the professors, Hungarian colleagues. It was a great pleasure to meet you again. And as Augustine said, I hope we will continue in the near future this fruitful cooperation. Thank you for it, and have a nice day. Have a good night for the Hungarians, and have a nice day for the Argentine colleagues. So see you soon. Bye.
Thank you. Thank
Goodbye.
you. Let's keep in
Bye.
contact.
Thank
Bye.
you. Thank
Mate,
you.
I will ask you to send me the recording.
Okay, I send the recording now.
Thank you.
Goodbye.
Thank you. Bye.
Thank you. Bye.
Bye.
Thank you. Bye.
Bye bye.